And so when you have those open matters, I might, for example, and I am thinking of a case where the absolutely open, I thought, or pretty open, what this statute really meant, and there were two ways of interpreting it, and one would have closed the habeas corpus door to many prisoners who I thought had done nothing wrong themselves to close it, and the other would have kept the door open. And I opted for the latter interpretation. And I will say, in my mind is the fact that in a country with traditions of affording justice to everyone and keeping that habeas corpus door open even to prisoners, where you don't know from the text, where you don't know from the precedents, you aren't certain what Congress meant by this language. Let's interpret it in accordance with those traditions. And there, I think, is an example of where something like a basic justice, a tradition of providing justice for individuals, can influence an interpretation of a judge, of an open language, even in an appellate court.
I know the case he's talking about. Yeah. I thought the language was pretty clear. But that, you know, that's what makes, that's
I think it said whether it was a state or other collateral proceeding. And the issue was whether the word other meant other state proceedings or other state and federal proceedings. I would say the word other, there by itself, is not so clear.
Well, so no, wait, this case, we're talking too abstract. Let's
oh, we are? I was talking pretty concretely.
Are we talking to Ed?
Let me come back to your original question. If people agree with Holmes and do not want their judges to simply apply their own notions of what's a good rule, but rather to follow as best they can what the people have decided through the Constitution and through the statutes, if that is the case, it follows that you cannot judge a judge simply on the basis of whether you like the outcome of the case, which is normally all you're going to find in a newspaper report. You're not going to find the textual gymnastics that the judges had to go through to reach the result. You're going to see, did the good guy win, did the bad guy win? And you're inclined to say, if the good guy won, wonderful judges, and if the bad guy won, terrible judges. That's not true, unless you believe that every statute ever written produces a sensible result. But, you know, the ideal rule for the honest judge is garbage in, garbage out. You are supposed to interpret the statutes reasonably, even if you don't agree with the result, because it's not up to you to decide what's garbage. And if you bear that in mind, you should be what should I say, more careful to either praise or criticize judges just because you like the outcome or dislike the outcome of their cases.
But I'm afraid I misunderstood. Are you saying that there's one case that you can recall since you've been on the Supreme Court where you personally disagreed with the outcome, but that the law, you felt bound by the law?
There are lots. There are lots. And you want me to go into some of them, and I won't because I haven't come here prepared with a list. And you have to read through them, and in cases that produce some outcome that's horrible, I probably disagreed with the outcome.
I bet you I have more than you do.
And where you're on dangerous ground here, you see Justice Scalia's last point, which is that to evaluate a case, and that's why I think one of the reasons that we're pleased that the people here are here, because they're interested in the details and they're interested in the cases. And you're on very dangerous ground because you're tempting us, you see, to join in our attack on, we won't say journalists, but we are the occasional article that doesn't go into it, in our opinion, in sufficient depth, which I'm sure you don't even know about.
Well, of course not.
No.
But how do justices constrain their personal views? I mean, how do they cabin their personal preferences? Justice Scalia, I would guess that you have a different view on that than you do, Justice Breyer.
No, I think we probably both have the same. It goes with the job. If you are incapable of producing a policy result that you don't like, simply because the statute requires it, and I do that all the time. I mean, I have decided cases preventing agencies from deregulating. For Pete's sake, before I became a judge, I was Mr. Deregulation. I was editor of a magazine called Regulation Magazine, which was all in favor of deregulating. But I've written several opinions which prevented an agency that wanted to deregulate from deregulating because the statute didn't allow it. And unless you can do that, unless you can realize that your job is to be faithful to the statute, you're in the wrong job. I mean, run for Congress or something. But
note, the Deregulation magazine is called Regulation, and now you begin to understand why law is a confusing subject. But I think here, you say an end that we both think, and I think that's true, that subjective judgment of the judge should not play a significant role in the outcome of the case. But where I suspect, and you can disagree, but where I suspect we tend to disagree is the means that judges will use to bring about that end. And what I usually say, and I don't know the point to which you agree, Nino, or not, but I think most judges, appellate judges in particular, when they face a difficult question of statutory or constitutional interpretation, I think they normally start with 6 tools. They have the text. They can look to the history. How do those words get there? They can look to the tradition, how those words have come to be used before and after. Precedent, the purpose of the statute, the statutory phrase in question, and the consequences. And by that I don't mean every consequence in the world. I mean the consequences that are relevant to the purposes and the statute at issue. The Fourth Amendment is about privacy, not speech. The First is about, say, speech, not privacy. All right? Now, I think we all have those 6 tools: text, history, tradition, precedent, purpose, and consequence. But I think some of us emphasize the first 4 and try to avoid the last 2. And they think that in doing that, it's less likely that you'll get subjective. I don't think that. I think you have to emphasize in many of these cases the last 2, purpose and consequence. And I think there are ways of doing that which are honest, writing down what you're doing, never having a secret or hidden motive, explaining to the reader exactly what's going on in the opinion, that act as a significant check on the subjectivity of the judge. And I think that's just as likely to be objective as to rely solely on the first 4. And I think it's at least equal 50-50. And if it's equal, I think that emphasizing the latter is more likely to keep the judge in touch with the legislature in a statutory case, which is in turn in touch with the people, and that is an appropriate thing in a democracy.
Purpose and consequence.
The problem with purpose and consequence is that they invite subjective judgment. To decide the purpose of a statute, it depends at what level of generality you look at it. Now, what is usually before us is whether a particular limitation in the statute should be applied or not. Is that limitation part of the statutory disposition? Well, if you say the purpose of the statute is to protect civil rights, and if you do not interpret it to have this limitation upon it, you will protect civil rights all the more. And therefore, you should adopt that interpretation. The problem is that the limitations in a statute adopted by the legislature are as much a part of its purpose as is the general purpose of protecting civil rights. No legislature pursues a general purpose at all costs. There are always some limitations. We're willing to do it up to here, but no further. And so to look at the broad purpose, which is what often happens in consequentialist opinions, is simply to beg the question. It's to assume the answer.